Lean in. We got breaking news. We got the Trump administration creating a constitutional crisis in the last 48 hours and challenging federal judges refusing to abide by their orders, saying to the world that the president acts alone and without any check or balance. He's wrong. I'll describe why and what the federal judge, Judge Boasberg in D.C., and likely the Supreme Court is going to do next off of some new recent filings just in the last 24 hours, one of them in the last several hours on Monday. I'm Michael Popok. You're on Legal AF. You come here for the breaking news and the analysis, and you stay for the breaking news and analysis. Let's get to it. Over the weekend, Donald Trump finally got around after 60 plus days of an administration to declare war. We're at war, ladies and gentlemen, with Venezuela, apparently, and with drug gangs that have been here for decades. But now it's some sort of imminent incursion, allowing the Trump administration to proclaim, short of declaring, war and using the Alien Enemies Act of 1898, the only time in peacetime a president has ever done that. And that has to be litigated through the court system. And a judge is going to have to declare whether that was constitutional or unconstitutional. An appellate court's going to have to do the same thing on the way to a Supreme Court, but not in Donald Trump's world. In Donald Trump's world and that of his administration, they can act until they're stopped by some sort of appellate court. They can completely ignore federal judges and federal orders that they find are illegal or powerless to stop Donald Trump. They even say it out loud. And now we've got the new filings. After much press reporting about the fact that Judge Boasberg, after a Saturday late 5 p.m. hearing, had ordered the Trump administration and expanded his temporary restraining order to include everyone subject to the proclamation of the Alien Enemies Act, everyone certified in that class that's subject to that order was blocked from being deported, period, full stop. As Judge Boasberg said, a very quick briefing schedule to get this case ready for an appeal. Today is the day that the Trump administration is going to have to file its opposition paper substantively, even in a court it doesn't respect or doesn't believe has any power over it. Are they going to ignore that order and not file and be in default? Let's see. In the meantime, the judge said Monday, Trump administration, you file. Wednesday, ACLU, representing the American Civil Liberties Union, representing the plaintiffs and the class of plaintiffs, you file. On Wednesday, we have a hearing this Friday. And we then let everybody go to appellate court. That wasn't good enough for Donald Trump. He decided to, let's get all these people out from under the jurisdiction of federal courts. Let's send them to El Salvador, to the philosopher king, Nayib Bukele, who runs El Salvador, and their most notoriously inhumane, disgusting black holes of detention centers in El Salvador. They sent over 200 people there on planes, some as young as 14 years old, some allegedly part of a gang, a narco-terrorism gang. They sent planes to El Salvador. They sent planes to Honduras. Problem is, they sent it after the court had already ordered them not to do that. At least 3 planes. Now, the press secretary for Donald Trump, and it's cited in the filing made by the ACLU just today, said, we don't respect, I'm summarizing, we don't respect federal judges. One single federal judge can't beat a president exercising war powers, and we're not going to abide by it. And the planes were already landed and jurisdiction has already been divested. I mean, that's effectively what they're saying. This is not the first time the Trump administration has tried to divest a federal judge of jurisdiction by taking them to a foreign power. They just did it a week ago by taking or taking it to a different jurisdiction. They just did it a week ago with the Columbia University graduate student who they took out of New York in the middle of the night and put him in Louisiana in order to get him out from under a New York judge's, Judge Furman's jurisdiction. This is the new game of the Trump administration. It's called shell game, moving people in and out of the states, in and out of the country, trying to divest the federal court of jurisdiction and then flouting it. So they had to file a notice to the court about what they did. And then the ACLU just responded this morning with Judge Boasberg basically saying that the Trump administration has confessed to violating your order. Listen to how not even carefully written, just listen to the confession implicit within this filing by the Trump administration just yesterday on Sunday. Federal defendants object to this court's assertion of jurisdiction. That's line 1. Including over the president's exercise of powers vested in him by Article 2, meaning you, Article 3 judges under the Constitution, you have no power to check the powers of the president under Article 2. They're obviously relying on the immunity decision from the United States Supreme Court last summer, but that was only in a criminal context, not in a constitutional co-equal branch of government checks and balance separation of powers context. Subject to that objection, the Trump administration continues, federal defendants were promptly notified of the court's restraining order in the morning and the 7:26-minute order that temporarily enjoined any removals. That's a lie. They were in court on Saturday at 6:30 when the judge ruled from the bench that all of those people needed to be stop being deported, and if there were planes in the air, they needed to be returned. They did it anyway, and they launched new planes after that. Federal defendants have sought emergency appellate relief from the D.C. Circuit as to both orders. Right, and the D.C. Circuit hasn't yet ruled on that. Nor do I think they're going to, given how quickly Judge Boasberg has set his own briefing schedule at the trial court level. Monday, Wednesday, Friday hearing. That's pretty darn quick. Appellate courts don't want to rule as of now, even though they may have jurisdiction because a temporary restraining order has been put in place, especially given the fact that the record's incomplete. Going forward, listen to this. This is a chilling line coming up next. Going forward, the Trump administration says, and in the absence of appellate relief, federal defendants will continue to protect the United States using authorities other than the proclamation. I don't even understand that. The judge said you can't deport pursuant to the Alien Enemies Act. You can't deport to foreign countries under due process considerations anyway. So they're saying in the absence of appellate relief, meaning until we're told to stop by the appellate court, we're going to ignore a trial court level? Federal defendants further report, based on information from the Department of Homeland Security, that's Kristi Noem, a very untrustworthy cabinet head, if there ever was one, that some gang members have been removed from the United States territory before the issuance of the court's second order. That's a lie. That's a lie, because the ACLU gives at least 3 examples of planes landing after or while the hearing was going on and after the judge had ruled. So that's a lie. Signed, Pam Bondi, Todd Blanche, Emil Bove, the former criminal defense lawyers for Donald Trump, now the highest levels of the Department of Justice. Now here's what the ACLU had to say about all that just this morning. First, the government's letter that I just read to you from states that the court's order was issued at 7:26 p.m. on Saturday, March 15th. But that was the written order. This court orally and unambiguously directed the government to turn around any planes carrying individuals being removed pursuant to the proclamation of the president. That's page 1. And they quote from the judge's order. You shall inform your clients of this immediately, that any plane containing these folks that's going to take off or is in the air needs to be returned to the United States, but those people need to be returned to the United States. However, that's accomplished, whether turning around a plane or not embarking anyone on the plane or those people covered by this on the plane. I leave it to you, but this is something that you need to be sure is complied with immediately. That's the judge. The oral order carries no less weight than a written order, so they're wrong. Secondly, on page 2, the ACLU continues, plaintiffs remain extremely concerned that regardless of which time is used, the government may have violated the court's command. The phrasing that they use strongly suggests that the government has chosen to treat this court's order as applying only to individuals still on U.S. soil or on flights that had not yet cleared U.S. airspace in violation of the court's order. And they point out they've been turned over to foreign governments to try to divest the court of jurisdiction, flouting the court's rules. And they list on page 3 of their filing at least 2 flights that took off while the hearing was going on and concluded after the hearing had concluded, so the order had already been sent out. Although that information was obviously in defendant's possession, plaintiffs nonetheless emailed counsel for the government with the information about 2 flights immediately after the hearing concluded. A Global X flight 6143 departing from Harlingen, Texas to Honduras, and another one from Harlingen, Texas to El Salvador. Third, even if only the written order is relevant, and even if the court had only meant to order defendants to turn the plane around if it was still in the U.S., plaintiff has serious concerns about the government's actions. They continue. And they quote the Axios article, quotes the quote of Carolyn Leavitt, the press secretary, that constitutional scholar, the written order where she said, the administration did not refuse to comply. This is on page 4. The administration did not refuse to comply with the court order. The order has no lawful basis, was issued after terrorist aliens had already been removed from the U.S. territory. That's a lie. The written order and the administration's actions do not conflict. This won't be the first time that Carolyn Leavitt lied, and I got called out by a federal judge. I'm sure it's coming up next. Moreover, Leavitt continues, as the Supreme Court has repeatedly made clear, federal courts generally have no jurisdiction over the president's conduct of foreign affairs, his authorities under the Alien Enemies Act, and his core constitutional powers to remove foreign alien terrorists from U.S. soil and repel a declared invasion. So now there's been a declaration of war without Congress? That's not how that works. A single judge in a single city cannot direct the movements of an aircraft carrier full of foreign alien terrorists who were physically expelled from U.S. soil. That's also factually incorrect. It wasn't an aircraft carrier. It was a series of planes. And yes, a federal judge sitting in one jurisdiction can enter an injunction off a class action certification or a nationwide injunction that does exactly that. That is the purpose of the checks and balance of having an Article 3 judge over an Article 2 exertion of power. Finally, some of the comments made by the philosopher king, self-declared, of El Salvador reinforce plaintiffs' concerns. This is on the bottom of page 5. For example, Nayib Bukele, the president of El Salvador, tweeted, Fed judges order after the New York Post said, Fed judges orders deportation flights carrying alleged Venezuelan gangbangers to return to U.S., blocks Trump from invoking the Alien Enemies Act, and added the comment, oopsie, too late. That's our foreign policy now. Oopsie, too late by El Salvador's president, to which Marco Rubio concurs in his tweet. And so they've asked the judge to get involved, to put it mildly. They want sworn declarations under oath from people in the administration about the actions taken, why they violated the court order, how they violated the court order, and they want the judge to get involved. This will run parallel with the briefing schedule the judge has already established. Today, the Trump administration needs to file its opposition paper to a move to dissolve the temporary restraining orders that are already in place. We'll see that paper. I'll report on it here. Tune back in later today on Legal AF. Wednesday, the ACLU responds and does the final brief. Friday, there is a hearing. There is an appeal started by a notice of appeal, but as of the taping of this, recording of this hot take, the D.C. Circuit Court of Appeals has not yet set a briefing schedule or granted an emergency stay of any type, meaning Judge Boasberg's trial court level injunction is the law of the land that Donald Trump is violating. Then we'll see. So parallel to the judge in his week-long, we have the D.C. Circuit Court. And then if Donald Trump doesn't like that, he can try to go to the U.S. Supreme Court. But given their recent past history, I think the U.S. Supreme Court's going to say, we're out of here. We're not, let the case develop at the trial court level. And then you can ask for your emergency writ. Well, wait a week. What's the emergency? You've been in office for over 60 days. You just got around to declaring the war, phony declaration of war just on Saturday. So we'll let the judge do his thing. The injunction stays as ordered. Now the Supreme Court's going to have, let me just end it this way. The Supreme Court's going to have to deal with this. You got an out of control presidency that's not respecting federal courts to which the Supreme Court is the head. If he disrespects federal judges at the trial level, it's not even a slippery slope. He would naturally disrespect appellate court rulings below the Supreme Court and ultimately the Supreme Court ruling if he doesn't like it. What are they going to do about it? This is the biggest constitutional crisis we've had between a president ignoring federal courts ever since Andrew Jackson. Bloody Andrew Jackson. We're back. I'll continue to follow it right here on Legal AF YouTube channel. Tune back in later today. We're going to have the report about what the Trump administration does with Judge Boasberg and what the appellate courts do on a very, very fast track. Fast-moving story. You're going to want to be here for it on Legal AF, the YouTube channel. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.